we have a major problem, which is that the European Court of Justice, in a famous case called the West Tankers case, in 2009 said, we're not going to tolerate these anti-suit injunctions issued from London and from Dublin and from Cyprus, I think, and from Gibraltar. And so that is the position that we now have in England, this rather schizophrenic view that they're okay if you're restraining non-European litigation in breach of the arbitration clause, but they are forbidden if the litigation is taking place, for example, in Sicily or in Spain, etc. Ladies and gentlemen, I have a couple of final remarks. The first of them is the question of finality. In England, questions of fact cannot be taken on appeal from the arbitration process. I suppose that's axiomatic. A question of law can go on appeal to the High Court, but only if, first of all, it is a question of English law as opposed to foreign law. Secondly, only if the parties have not agreed to exclude this possibility of High Court appeal. And thirdly, only if the High Court itself gives permission for the appeal to proceed. So this is a controlled form of appeal on a question of English law. The final point, ladies and gentlemen, and thank you very much indeed for your patience. The final point concerns the New York Convention, 1958. Here I would like finally to draw to your attention a very interesting and fairly recent Supreme Court decision in England, which is called the Darlah, D-A-L-L-A-H, the Darlah case. In this case, there had been an arbitration in Paris. The members of the tribunal were a former Chief Justice of Pakistan, a former member of the House of Lords, the Judicial House of Lords, and a Lebanese lawyer. So, three members of this tribunal. And the question, or one of the questions, was whether in the relevant arbitration clause, the government of Pakistan was a party to the arbitration clause. The government of Pakistan was not named as a party to the arbitration clause, and the government of Pakistan had certainly not signed the arbitration clause. So prima facie looked rather like a non-party, therefore. However, using the alchemy of modern French arbitral jurisprudence, the Lebanese member in particular became enthusiastic in favour of a theory that although the government of Pakistan wasn't named as a party and wasn't a signatory, nevertheless, in fact, this was a party. And so the award that was given was against, amongst others, the government of Pakistan. I should say that the main transaction in this case had been structured so that the government of Pakistan had actually used a trust rather than signing the relevant agreement in its own name. So that was the background to this case. So we have a Paris award against the government of Pakistan, in which there is a preliminary decision that the government of Pakistan is a party. They now take this award under the New York Convention to London. And the question is whether the High Court in London should recognise and enforce this Paris award. The Commercial Court judge said no, because having heard expert evidence from highly expensive Paris lawyers, we take the view that the arbitration tribunal in this case has failed to apply properly French arbitration principles governing the identification of true parties to the arbitration clause. So, ladies and gentlemen, this is a second de novo hearing of a complex point of law where they second guess a decision based upon essentially French principles in Paris. The English Court of Appeal agreed, and the UK Supreme Court agreed. So at all three levels in England, the decision was that the Paris tribunal decision should not be recognised under the New York Convention. Plan B was that they would seek to enforce the Paris award in, I would have thought, the more obvious jurisdiction, namely France. And the last time that I was able to track this, the Cour d'appel in Paris, applying French, pure French, domestic arbitration principles, agreed with the arbitration tribunal that in fact the government of Pakistan truly was a party to this arbitration agreement, and therefore, subject to a final possibility of appeal in France, this case will proceed within France for enforcement. So, ladies and gentlemen, thank you very much indeed for your patience. I have slightly exceeded my time, and that is because I wanted to assist Natalia, who I'm sure has done a splendid job in trying to unravel my slightly complex English at times. Thank you very much indeed. It's been a great pleasure, and good luck with the exciting world of arbitration and mediation. Thank you.